Hello, for On Subrogation, I'm Jason Sullivan of Rathbone Group, and in this video we're going to talk about contribution between tortfeasors. A common scenario that arises is a three-car collision. There's one innocent party in front, your insured is the middle driver, and there's a third vehicle behind them. It's disputed what happened, but allegedly your insured ran into that first innocent vehicle, and then subsequently the third vehicle ran into the back of your insured. That first vehicle looks to you and says, I felt that first impact, it was really strong, they caused all my damages, they should pay. Now as an insurance carrier, you're going to adjust that claim, and maybe you're going to pay out on the liability for that because there is some fault on your insured, or at least it appears that way. So you settle the claim. You pay 100% of that first party's damages. Can you get any of this money back? Under states that have adopted a contribution between joint and several tortfeasors, the answer is usually yes. If one party pays more than their fair share of a loss, they can recover it from other tortfeasors who share in the responsibility. So in this case, where your insured arguably has some fault running into the first vehicle, but that third vehicle may have some fault for running into you and pushing you into them, furthering the damage, causing additional injury. Now, contributory or contribution between tortfeasors is usually adopted in each state by statute, and it lays out all the scenarios in which you can seek contribution from another tortfeasor who shared in causing the damages that you've paid for. Some caveats that are really common are, you have to pay for the other party's liability in full before you can seek contribution. You can't settle a portion of the claim and then seek contribution while they still have their own exposure. Another is that if your party, your insured, caused the damages intentionally, in those cases there's no contribution if you've intentionally caused harm to another person. Most motor vehicle collisions, that intentional part does not come up, but it is something to be aware of when you're trying to decide, is there another party that's shared in the responsibility, and then can I recover from them? One thing to keep in mind is you may have a shorter statute of limitation or a different statute of limitation when you have a contribution claim against a joint tortfeasor. That statute of limitation may run from the date you make the payment to the injured party as opposed to from the date of loss, and it may be shorter than what your state's typical standard negligence statute of limitation is for just regular injury. You always want to look at the state that you're in to understand whether or not that contribution from a joint tortfeasor has been adopted by statute and whether that is the law in the state. And if it is, then you want to look for any other party that potentially shared in the responsibility for those damages and determine what their percentage of fault is and is it worth pursuing them to recoup that money back. Clearly, any money back in your pocket after you've paid for the liability claim is good from a subrogation standpoint so that all parties who caused the loss share in the responsibility. For On Subrogation, this is our video on contribution between tortfeasors. If you have any questions, please send them to us at video@rathbonegroup.com. I'm Jason Sullivan of Rathbone Group, and that's the long and short of it.